So thank you all for coming. My name's Joe Garuba. I'm the Managing Director here at BW Fox Tucker Lawyers, and I'm also the Head of Litigation. Today we're doing a presentation, myself, Helene, who's one of the partners in my team, and Ben Duggan, who's the partner in charge of the Employment Healthcare Relations team. And we're talking about important topic that's quite for our hearts, I think, confidential information, how to protect that and protect that very valuable asset in your business. So many of you are in different types of businesses. Here you're in professional services, you're in advisory businesses, you're in companies that produce products, and all of those businesses have different types of confidential information and assets that you want to try and protect. The problem that we have is that one of the aspects of growing our businesses is that we try and get people to develop strong and trusted relationships with the clients. As a result of that, the clients often align themselves with the individuals rather than with the business itself. This leaves the businesses vulnerable when senior members of those teams leave. So what we're going to be doing today is talking about those businesses, how you can protect them by way of agreements, the importance of valid and enforceable restraints, and having really good confidentiality clauses, particularly in respect of people in the manufacturing industry that are protecting trade secrets and those types of indemnity clauses and how we can use those, and trade advantages clauses. And we'll talk a little bit about what to do when staff members resign, deal with that, and then the unfortunate situation where you're not getting any joy out of getting people to act reasonably, what litigation looks like, and how it's. And then there's going to be, we'll get Ben talking about the possible changes on the horizon with the federal government's proposal to regulate restraints. The first thing we'll talk about is agreements. This is the first layer of protection, and it's to protect client lists, databases, and confidential information. Now, a restraint clause in a contract comes into effect when someone leaves the business, but enforcing the restraint can be difficult. There's a number of different types of restraints. You have a non-competition restraint, which prevents a former employee from competing against the company. You can have a non-solicitation restraint, which prevents the employee from approaching other employees of the company. You can have a non-recruitment restraint to prevent the employee from recruiting other employees of the company. Then you have the confidentiality agreements, which protects the confidential information and trade secrets. What's interesting about this area of law is that prima facie, these restraints are unenforceable as they're contrary to public policy. The reason being that it's not a good idea to stop people being able to work once they leave. So the general idea, let's try and keep everyone working. So the idea is, let's make them against public policy. Let's look at non-competition clauses first. As I said, the restraint of trade is presumed to be void as contrary to public policy. Now, a business can rebut this presumption if it can demonstrate a couple of things. Firstly, that it's reasonably necessary to protect the business's legitimate business interest, and secondly, that it's reasonable in the interest of the public. Now, what does that mean? What gives an employer a legitimate interest? So what the courts have said over time is that where the employee has access to confidential information that goes beyond mere know-how, and they may be in a position to use that knowledge to the employer's detriment, then that's a legitimate interest for the employer. Where it wants to protect trade secrets and business goodwill, that's a legitimate interest. And where the employee's work involves personal contact with the employer's customer, and they may be able to use that connection to try and get the customers to come over to them, that's a legitimate interest. Secondly, the restraint clause needs to be considered at the date the parties entered into the contract. Now, what that means is you have a look at the work that person is doing at the time that you enter into the contract, and you've got to make the restraint appropriate to that person at that time. If someone then moves into another different role, more senior role, then you need to give some consideration to what the restraint should look like at a later time.
Would you put a new contract in place at that stage?
Yep. And you can do that because you're changing the person's. Okay, competition clauses. Thirdly, the restraint of trade is to be approached by looking at legitimate interests that you're trying to protect and determining whether the clause is broader than necessary for that protection of those interests. This means you shouldn't just use a blanket restraint prohibition, for example, restraining employees from working in the industry for 12 months or 24 months. It needs to be tailored for the individual. You need to look at things like the seniority of the person, the influence that that person might have in the business, and the impact that that employee might have in the workplace with clients. So it's very important that we look at precisely what that person's job is, and you tailor the restraint to that. What happens, or what we see quite a lot of, is businesses that will have an employment contract and they'll just roll it out for everyone. Everyone that gets employed is exactly the same, and that can be very problematic. So the court will probably look at striking down restraints where they're not appropriate. Courts have used a term of art which is called a blue pen, and what they'll do is read down a restraint clause if it can be made to be reasonable by striking through sections of it. So we'll just talk a little bit about how the court has used that power in order to make clauses ensure. So the couple of cases we're going to talk about. First one I'm going to talk about is the Just Group and Peck case. So that's one of the leading cases, and in that case, Ms. Peck was a CFO of the Just Group. She had a number of, Just Group had a number of subsidiary brands, so Nibbles, a lot of these will know, Peter Alexander, Just Jean, JJ's, Altman's, Jackie E and Dottie. Ms. Peck was employed for a short period of time, 6 months, from January 2016 to June 2016, and then she moved to a new role as General Manager of the Cotton On Group, competitor. Her employment contract contained a very lengthy restraint. It was for 24 months and listed about 50 businesses that she was restrained from going to work with. Cotton On Group was one of those 50 businesses that she wasn't allowed to go and work with. The court said that her contract restricted her from working with any retailers or fashion brands, not just those who would be competitors to Just Group. The contract had the effect that she couldn't work with companies unless Just Group's confidential information was not relevant to them. They weren't one of the 50 companies. The court held that in the first instance that even the minimum 12 months was too long, and they considered that in the circumstances where during the probation period Just Group could terminate her employment with 1 month's notice, but then expect her not to work for 12 months after termination, that was not reasonable. On appeal, by the Just Group, so they appealed the decision. The court held that a list of 50 businesses was not a separate restraint that was capable of severance. So this is what we're talking about. Can you just take part of the clause out and then leave it enforceable? They said that the disputed clause must be capable of simply being removed, as if crossed out with a blue pen. That's where we get that term of art from. A court can only remove words from a restraint clause. It cannot rewrite the restraint clause. So the job of the court is not to try and fix up something that you've got wrong, to actually say, well, by taking this bit out, doing very minimal to the contract, we can still have it enforceable. Part of the clause to be severed must be independent and capable of being removed without affecting the remaining part. It's important to note that the courts are reluctant to engage in what they term as disentanglement of unreasonably wide restraint clauses if the clause is not a genuine attempt to establish reasonable protection for the legitimate interests of the business. So again, you're getting that terminology coming through, that what you need to do when you're trying to put the restraints in place is to look at what the employment relationship is and what you actually need to do to legitimately protect that relationship. Second case I want to talk about is AGA assistance and property. It's a Queensland case, and in that case there was extensive evidence that the former employee held a senior and influential role within the company and had direct dealings with key clients. The court said that it was important in assessing the reasonableness of the restraint that the former employee's role brought her in frequent contact with key clients who were likely to be influential in granting new or future business for the employer. The court then said that the former employee was a human face and she represented the businesses to the clients. Therefore, the relevant interest to be protected was the relationship the former employee had developed with clients and which were acquired in the course of her employment. What quite often goes hand in hand with a restraint clause is a non-solicitation clause, and you've no doubt those in your contract as well. They're drafted together to form a sort of a cascading level of protection. This is necessary because the bar for restraint clauses is often much higher than non-solicitation clauses. And so it's good to have the two of them working together. Solicitation clauses have been given a broad interpretation by the courts, acting upon contact initiated by a client of a former employer may still be considered the solicitation. So it's interesting the way the courts have interpreted what constitutes solicitation. So we'll go through a couple of cases just to give you a bit of an idea of the way the courts look at it. The first case I'm going to look at is Barrett versus Echo Personnel Proprietary Limited. Barrett was contacted by an officer of Nestlé days after leaving employment at Echo for the purpose of submitting a proposal as an industrial consultant to Nestlé. Barrett, so he was contacted first, so he didn't go to them. Barrett submitted the proposal and subsequently attended a meeting with Nestlé, and Nestlé liked what they saw and they proceeded with giving Barrett the job. Proceedings were commenced by against Barrett by Echo, against Barrett, and he said that he did not canvass, solicit or entice any client away from Echo as he was invited by Nestlé to submit a proposal. He didn't make the initial contact. At first instance, it was held that although Nestlé provided Barrett with the window of opportunity, it was Barrett who solicited and enticed Nestlé through the proposal. Stein J, on an appeal, said that the meaning of the word solicit includes to call for, to make request, to petition, to entreat, and to persuade. So the last two parts of that definition, to entreat is to deal with, and to persuade is to obviously try and get the work, even though you were not the one who started the initial communication. He said that Nestlé's invitation was the catalyst or trigger for the solicitation by the appellant, and that this did not make the appellant any less the mover for the action happening. As a result, the court held that Barrett solicited the business of Nestlé by submitting his proposal to them despite not having made the initial contact. So I think that's always important, because what you'll see quite often when someone leaves, they try and manufacture a situation where the clients come to them rather than they making the initial contact with the clients, and they think that if they're able to manufacture that sort of situation, sometimes through social media or other types of things, that they're home and hose. That's not the case. Second case we're going to look at is Pearson versus HRX Holdings. In that case, Pearson was the employee, held a unique position in the firm, fostering relationships between clients and the company. Now, Pearson was active in the establishment and direction of HRX's business, and during his employment, he had access to virtually all of HRX's confidential business information. Pearson was referred to as the Rainmaker, and he held a number of executive positions. In his position as HRX, one of the things he dealt with was post-employment restraints, and he made sure that all those restraints were negotiated with the staff of HRX. He also negotiated his own restraint, and it was similar to the restraints that were appropriate for people at his level in that business. He controlled customer connections, and the court was satisfied that the post-employment restraint, which included a non-compete clause, was a reasonable measure to protect the legitimate interests of the business. So this is an interesting case because it shows the relationship between non-solicitation and non-compete, where the court said that because of his relationship and the closeness he had with the clients, it wasn't appropriate just to leave a non-solicitation clause as the effective restraint. There needed to be a non-compete clause as well, and they said that both of them were appropriate. Last case we're going to look at is Coops and Dean Reeves, and that's a decision by Justice Brereton, and he maintained that where the former employee has a strong personal connection with the employer's clients, a non-solicitation clause is more appropriate. He said the stronger the customer connection that the employee develops, the less solicitation is required. The strongest connections are those in which the client will follow unsolicited because of his or her connection with the employee, notwithstanding that the connection belongs to the employer. So it's the court recognising the fact that the reality of the situation is that in businesses that have client relationships, quite often those relationships become very, very strong, and it's very hard to break those relationships and leave the benefit of the client relationship where it belongs, which is with the employer. He said an anti-solicitation clause is insufficient to protect an employer's customer connection in that context. And he then said that a restraint that goes beyond a non-solicitation clause, most notably a non-dealing restraint, will be reasonable where an employer is attempting to protect their customer connections and as such stop the former employee having any contact with its clients. He then went on to say that a non-competition clause, particularly with reference to a territorial distance, is far more anti-competitive than one limited to prohibition acting for former clients of the employer. So they looked at the two aspects of a non-solicitation, that is actively going out and seeking the work and not being allowed to do work for those clients. And he said that in the second instance is where it's appropriate to let the court enforce that sort of restraint. Social media is an interesting piece that we all struggle with, and has reared its head in this area. A lot of professionals notify people that they've moved their job, either through LinkedIn, Facebook, Instagram, Snapchat, whatever it is they're using these days. However, whilst people are still bound by the restraint and the non-solicitation clause is in place. What's interesting about that is the way the courts have interpreted what you're allowed to do and what you're not allowed to do on social media. One of my favourite cases is this one here, Planet Fitness and Brooke Dunlop. That involved a very brazen communication style by an ex-employee of a fitness business with previous clients. So Ms. Dunlop, she was a personal trainer, had a non-solicitation clause in her employment contract preventing her from directly or indirectly soliciting, canvassing or securing the custom of any client. After she leaves Planet Fitness, she contacted a number of her previous clients and advertised on her Facebook account discounted membership rates for people she had previously trained. One of the things she put on her Facebook post was, "I have negotiated an amazing deal exclusively for any of my PT clients, PC members and class participants. Please call Sean and the guys at Genesis. All you need to do is mention my name and show your current membership tag." And that was all really okay. Now, of course, her previous employer got permission with that, and they filed interlocutory proceedings in order to enforce the restraint and the non-solicitation clause. And the court agreed that it was clear Dunlop had solicited, canvassed or enticed former clients, and in analysing the clause in the employment contract, they said, as a whole, the clause is a restraint against endeavouring to attract or achieving the attraction of custom of the former clients of the first defendant after her contract with a plaintiff had been terminated. There is a strong prima facie case that the first defendant has solicited or canvassed persons whom she provided personal training services when she was contracted to the plaintiff. She did so by posting messages on her Facebook page in which, amongst other things, she advised her Facebook friends that first she was in negotiation and later that she had negotiated arrangements with Genesis, whereby those persons would be able to train at Genesis clubs at a reduced rate for remaining periods of their contract with the plaintiff. So it's one of those areas where we're seeing more readily used, and Helene will talk more about this and what we do about scanning through people's accounts to see what they've been doing, because it can quite often be a very a good area of getting information. All right, I'll pass over to Helene and she'll talk a bit about confidentiality and other things moving forward. Thanks, Helene.
All right, so I'm just going to jump straight into confidentiality. Now, implementing a strict duty of confidentiality clause into any agreement is a strong layer of protection that will offer you another avenue to pursue on top of what Joe has already spoken about. So when you're going to get a contract, you want to ensure that you have a definition of confidentiality that will include things like clients' names, telephone numbers, email addresses. Even, if you're in the financial services industry, you want to look at investment portfolio details and any other data that is not actually publicly available. And this clause will also provide that the information about your business, its affairs, its products, its financial accounts and reports are all confidential. What you want to do is...
Can I just ask about confidentiality, and you talk about client name, telephone number, email address. Public domain, that's available in the general ether, right? So how can you put that as a obligation, a contract?
Yes.
It's generally available.
A lot of this information isn't generally available. So if you have, for example, the financial services industry and you have a list of clients, their mobile numbers, email addresses and things like that aren't publicly available. The only way they've obtained those details is through their employment and through the time and money that the employer has invested in these individuals to generate those contacts and those relationships. So it isn't publicly available.
Okay, well, I can see that.
That's okay. Now, what you want to do is to ensure that all the information that is obtained about a company that is obtained during the course of somebody's employment is by its nature confidential, is captured by that clause. Now, the practical implications of this means that all the other information obtained about a company during the course of that person's employment that is used can therefore be captured under this obligation and therefore followed up potentially as a breach. It's also important to note, and this is a critical aspect, is that duty of confidentiality operates beyond somebody's employment. So in our experience, we've actually found that the confidentiality clause is probably one of the most efficient mechanisms to protect a business. And for example, its client lists and databases, it's certainly a quick recourse available to businesses. Now, another factor to be wary of is which entity is actually suffering the loss. So corporate structures can be quite convoluted. Often for me is engaged through separate entity in comparison to the one that's actually carrying out, for example, services. So therefore, this can create issues down the track as to who's actually suffered the loss. So in our experience, early consideration should be given to drafting indemnity clauses in contracts. So by way of example, and I'll lean again on the financial services industry, we often see that via an agreement between an employing entity, for example, company A, the entity providing professional services being company B. So a clause will exist which provides that company B, if company B suffers any loss and damage as a result of the actions of company A or its agents, employees, contractors, then company B may recover its loss and damage from company A. Now, then an indemnity clause should be inserted in an agreement with the employee or advisor in their contract, enabling company A to claim that loss and damage from the employee, the advisor. Now, that clause must be carefully drafted so that it isn't too broad, because what we want to make sure is that there is a causative link between the actions of the employee or the advisor, the breach, and the loss suffered. Liquidated damages clause in a contract is also often a very attractive from an employer's perspective, and it's not difficult to see why. Now, such a clause does provide certainty and does away with the burdensome task of assessing the damages payable upon an occurrence of an event such as a breach of contract. However, as you can anticipate, a liquidated damages clause is susceptible to challenge on the grounds that it is a penalty, and therefore it can be deemed unenforceable. I won't delve too much into what High Court has said in relation to liquidated damages clause and when they're a penalty. However, I will just draw a few quick highlights. Now, High Court has observed that the essence of a liquidated damages clause is a genuine pre-estimate of damage. And that is something that will roll through and through my mind every time a contract comes across our desk where there's a potential breach and it contains a liquidated damages clause. Is it a pre-estimate of damage? Now, the question whether a sum is a penalty or a liquidated damage is a question that is dealt with at the time of the breach. And often it is held that a clause will be a penalty if, for example, it's just a lump sum payment. So a payment of $500,000, and there's been no actual consideration put into, is that a genuine estimate of the potential damage? So the other consideration is whether it is extravagant and is simply unconscionable. So, for example, if we enter into a contract where there was a loan of $250,000, but there was a liquidated damages clause of $200,000, and then you have to sit back and think, okay, well, is this actually unconscionable now? Seeking such a big lump sum payment in comparison to the loan amount. Now, in our experience, an agreement which sets out a formula to calculate the damages is often helpful, and it is positively looked upon by a court, and it just doesn't contain a lump sum payment. So a very good example, probably one of my favourite examples, is Bird & Co Nominees Proprietary Limited and Money. Now, this is a Victorian Court of Appeal case in relation to an accounting firm. Now, they considered whether the liquidated damages clause triggered by a former employee's breach of their restraint of trade clause was actually enforceable. Now, the contract contained a restraint which was governed, of course, the employee's conduct for a period of 3 years after the cessation of their employment. Now, the contract made it a breach by the employee if he or she were to later provide accounting services to a person who had been a client of Bird and Cameron, and for whom, and for example, Mr. Money, who is the defendant in this case, had provided accounting services to during the 3 years before his employment ceased. Now, in the event of such a breach, it was provided in the contract pursuant to the liquidated damages clause that a sum equal of 75% of the fees incurred by the client in the last full financial year in which the client had remained a client of Bird and Cameron is payable. Now, that's the type of formula we're talking about. Now, the court held that in that case, the interest that Bird and Cameron had and sought to protect was essentially the customer or trade connection that Bird Cameron had with those clients who dealt directly with Mr. Money. And the restraint was very well crafted in that. Now, that customer connection is a legitimate interest of the employer that is capable of contractual protection. Now, Mr. Money conceded at that time 75 cents in the dollar was a reasonable pre-estimate of the price to acquire a parcel of fees of clients in an accounting practice. So the court upheld that liquidated damages clause as enforceable.
Is that over the 1 year fee or 4 year total fee?
That was 1 year. 1 year. So now it comes to what to do when things, so you've had a senior staff member leave, you're suspicious about what has happened. In our experience, you have to be decisive in your actions. Request confidential information be returned immediately. To this, the request should particularize the information that is confidential, explain how that information is confidential. If you suspect the confidential information is being used, then the letter should set out the circumstances of its disclosure. We also recommend explaining the ongoing obligations to keep confidential information confidential post their employment, and set out consequences of non-compliance. Consider monitoring and undertaking a forensic analysis of their computer, their mobile telephone, especially, of course, if it's a company property. This will show whether or not, for example, documents have been downloaded, printed, created, deleted. Monitor social media accounts such as LinkedIn, Facebook, WhatsApp. Monitor and the flow of work. That is something that is critical. We have, in previous cases, come across patterns where meetings are set up on a periodic basis, and all of a sudden, all those meetings have been postponed to a date after the employee has left. It creates a basis for either the clients or the former employee to reach out. So people are crafty, so just be aware of your business and the routines and the habits and what's missing. And if something is wrong, move quickly.
Sorry, can I ask a question? I did all of that and they refused.
They refused. So you sent them the letter.
I had proof.
You had proof. And then that's
Downloading intellectual property, downloading private confidential information.
And that's when we step into the next step of litigation, which I know. I know nobody likes us. It's okay.
Yeah.
I know, and that's
No.
the steps that you've taken and we have taken. Set yourself up now for this next stage, which is going to court. I don't think it's uncommon for people to call a bluff and say, well, what are you going to do about it? And that's where it brings it to to the next stage.
Yeah.
Which I can understand everybody's hesitation moving it on to the court system. But, you know, if you're talking about these people that are brazen, and they certainly probably wouldn't align with your morals, then
it came down to the jurisdiction. If I wanted to do anything further, I had to go through the Commonwealth jurisdiction, which is thousands.
So obviously we've got the federal court, and it is a much higher filing fee. That is correct. Depending on your contract, that's why we have duty of confidentiality. That we have, and there are also common law duties as well that can be relied upon. And I'll delve in a little bit later as well, but there are other breaches under the Corporations Act, depending on the seniority of the staff members, for example, breach of duties of officers and things like that. So there's many ways to skin cat. Yeah. To be frank. So yes, the federal court is an expensive filing fee sort of aspect of it. It does move fast though, so there are benefits to going through the federal court system in comparison to courts. But there are many ways to approach it, and you don't just have to.
Okay, thank you.
So if you do start to notice clients are terminating their engagement with you, or there is a decline in work that is usually there that stems from your client base, swift and decisive steps are required. So first, we would send a letter requesting an undertaking that is consistent, of course, with the terms of their restraints and the clauses of confidentiality. Second, if the undertaking is not provided, an interlocutory injunction should be filed as soon as possible, seeking orders in the terms of the restraint, for instance. Now, interlocutory injunctions provide a means by which the court can hear applications quickly in situations where, of course, time is of the essence. And therefore, before a final determination is made and a permanent injunction is granted, it is about maintaining the status quo, and that is what protects your business. The court will not conduct a mini trial, and they won't seek to predetermine the outcome of the final hearing, and it won't determine things like the credit of witnesses. Rules of evidence are relatively relaxed. That means that hearsay is permissible. So it's important to remember that when making these applications for an injunction, the court will require the parties seeking the injunction to give an undertaking as to damages. Now, this is a commitment to pay compensation to any other party, which can actually include third parties, so be aware of that, if they suffer damage as a result of the injunction, if the court eventually overturns the original injunction. Now, in the High Court case of ABC and O'Neill, the court very much outlined the three key elements when looking to grant an injunction. The first is there's a serious question to be tried. So that's, is there a prima facie case based on the evidence that's before the court that there's an actual issue here? For example, yes, there's an actual issue here. This person's downloaded all of our confidential information. Here is all the evidence. It's pretty slam dunk, I'll be honest. We need to show that damages will not be an adequate remedy, and balance of convenience favours granting the injunction. So damages not being an adequate remedy, I'll have a look at this case for LCR Group and Bell. Now, this is actually a Supreme Court of Queensland case where a former employee has breached the restraint of trade in his shareholder agreement with the employer's parent company. Now, the court held that by taking a position with a competitor, the employee would be in a conflicting position where his performance of that role would entail a significant risk of detriment to the former employer's commercial interest through the misuse of confidential information. And it was found that damages would not be an adequate remedy because the breach of restraint of trade, where the clients are being unfairly solicited, will result in a substantial damage to the goodwill of the company. And that's the key, is the damage to the goodwill of the company. Balance of convenience. Now, when the court looks at granting an injunction and balance for convenience is obviously the third element. What they want to look at there is what course will most likely achieve justice between the parties. So whether we like it or not, they'll always look at the impact it's going to have on the respondent, on third parties, questions of hardship, availability of alternative remedies, delay, and of course any undertakings that might have been offered by the respondent, and also the respondent's conduct. That's another element that's always taken into account. Now, once an interim injunction is obtained, the matter then proceeds forward through the court system by way of a statement of claim to determine whether or not a permanent injunction should be granted. Now that brings me to our next step, which is collating the evidence that is required to successfully pursue a claim. Now, these type of cases are unique in that all of the knowledge of the breach is actually retained by the former employee. So, as we previously flagged, undertaking a forensic analysis of your former employee's computer, email, telephone records, all of that is vital. We think it's very important to consider things like what documents have been accessed over the past 6 to 12 months. What confidential information has been accessed or provided or kept? What has been downloaded? What has been printed? What screenshots of confidential information has actually been taken? Have documents or information been sent to from work emails to personal emails? That's a real common one. Has information been withheld? For example, like I said, delay of client meetings. Have staff members been emailing clients with their personal email address? Again, that's another one that always trips people off. Consider steps such as issuing third-party notices or subpoenas on former employees and any former clients for production of emails, telephone records, LinkedIn, Facebook messages, WhatsApp messages. I don't know if people use Snapchat, I don't know. So all of that type of stuff. Like I said, people are creative and they will look at ways to get around things, but it needs to be a deep dive. In our experience, a subpoena enables us to analyse the evidence obtained from the former employee and establish any inconsistencies or cover-ups. That has proved very successful. For example, we had a case where there was an advisor who stated that he didn't initiate any contact with former clients. However, upon subpoenaing telephone records and the former client's telephone records, we could see instances where he would call quickly after 2 or 3 seconds, hang up, and then that client would call back and say, oh, I had a missed call. And then there would be like a 15 or 20-minute telephone conversation. And this all happened immediately after his resignation. So that was very damning evidence. Now, I very briefly mentioned this. So these are the other claims to be aware of, which are third-party claims. So in some cases, it may actually be open to pursue your senior members for breaches of duties under the Corporations Act, pursuant to sections 181, 182, 183 and 184 of the Corporations Act. So you need to look at whether the person is intimately involved in all of the important decisions affecting the company. And if you can establish that someone is an officer of the company, there are certain obligations such as those that are contained in the Corporations Act that are applicable. Another potential cause of action is whether the new employer or new company knowingly assisted in a breach of fiduciary duty by the former staff member. This is one that is often overlooked by people. That should not be. Now, the leading authority on this is the High Court case of Ancient Order of Foresters and Victoria Friendly Society Limited and Lifeplan Australia Society Limited. Now, this is a long and substantial case and it's gone all the way through to the High Court. However, I'll just provide a brief summary of the important material facts. And also, I will say this is the everything lined up in this case. Often you don't get such slam dunk cases. Now, Lifeplan, through its subsidiary, FPM, provided products to meet the cost of pre-arranged funerals. Foster's was also involved in the funeral products business, although it had a much smaller market share, and Forrester's business was not profitable. Now, there were two former employees, Wolf and Corby, who were employed by Lifeplan as managers at FPM. But in 2010, they approached Forrester's with a 5-year plan to divert Lifeplan's existing funeral products business to Forrester's. While still employed by Lifeplan, both these guys presented a comprehensive written proposal to Forrester's using Lifeplan's valuable commercial information, including name of client referrers and associated past and projected revenues. The proposal set out a detailed 5-year plan of attack to attack the client base of Lifeplan with a view of bringing it across to as many clients as possible to Forrester's as quickly as possible.
They have to use their own work email. Like, how did you
Yeah,
cover out? Did it?
So yeah, with discovery.
Yeah, right.
And the mechanisms to require parties to produce documents.
Yeah, right. Yeah.
But there are a few other things that lined up which certainly assisted to lead evidence. The other thing as well is that we've had cases where we've gone off to third parties, like the new employer, and through the discovery process, or if they're not party, a non-party discovery application, you obtain all that information because they are ordered and they are compelled to produce it. They cannot hide it. So yeah, and this case is blows your mind a bit. Now, the proposal was considered by the Forrester's board and ultimately approved. Both the primary judge and full federal court found that Forrester's would not have proceeded with the plan without reviewing the proposal, including the confidential information of Lifeplan upon which it was based. Both these guys proposed to run this business through a company called Funeral Planning Australia. Funeral Planning Australia was incorporated while both of these guys were still employed by Lifeplan, which isn't that you are actually allowed to start to set yourself up if you are branching out. You just can't use information. Now, while they were still employed at Lifeplan, both these guys took steps to implement the plan. Now, this included preparing documentation and Forrester's marketing material and attending initial meetings with client referrers designed to be targeted in the first year. Following their resignation from Lifeplan, the plan was implemented by these two guys as employees of Forrester's and proved to be highly successful. Forrester's revenue went up from 1.6 million in 2010 to 24 million in 2 years. Interestingly, Lifeplan's revenue decreased from 68 million to 45 million over the same period. Lifeplan and FPM commenced proceedings against both of these individuals, as well as Funeral Planning Australia, for breaches of fiduciary duties towards them as employers, as well as contraventions under the Corporations Act. Forrester's was subsequently joined to the action on the basis that they had knowingly assisted in the breaches. And the court held that there was a sufficient causal connection between Forrester's knowing assistance in the breaches. The court held that it was sufficient to show that the profit had not been made but for the dishonest wrongdoing, and it is necessary to consider the overall effect of the knowing assistance rather than the direct consequences of each act. So in making those findings, the majority observed that Forrester's played an integral role in the breach of duties by Wolf and Corby and construed the benefit derived by Forrester's as being the business connections of Lifeplan rather than the individual streams received from customers. Lifeplan and Funeral Planning Australia correctly and smartly elected to claim and account for profits for the entire value of Forrester's funeral products business. Now, this case highlights the expansive remedies that can be ordered against a party who is found to have knowingly assisted in a breach of fiduciary or statutory duties under the Corporations Act, including an account of anticipated future profits not yet, and potentially not ever received. The decision serves as a warning to those who knowingly assist employees, directors or officers and other fiduciaries to breach their duties, that the financial liability of such conduct will outweigh the actual benefit that is received. So if there are any suspicions of knowing assistance, it is prudent to write to that other company to put them on notice of any potential claim against them. On that note, I'm going to pass over to Ben.
One thing, the authority just kept on appealing. So if they lost, for instance, they lost on appeal, they lost their special leave application to the High Court. Sorry, that they did, so they succeeded on a special leave, and then they lost in the High Court. Every time they lost, the damages went up.
Yeah.
So the first damage was about $1 million. The second lot was about 7 or 9 million, and then the High Court said, "Nah, we're going to make it 24 million." So they just kept on losing.
Yeah.
You sort of just put while you're ahead.
Yeah, and that is it is an ideal case to demonstrate what not to do. And I'll hand over to you.
I'm just going to finish off the talk today by talking about some proposals at federal level in relation to regulation and restraints. So restraint protocols which have been discussed today have certainly become more common in years. Labor initially excluded this topic in its IR platform in the lead up to the 2022 election. More recently, Treasurer Chalmers had provided some further detail about his plan in his most recent budget earlier this year. The aim of the plan, and this is how it came out through the budget, is to increase productivity. In terms of the scope of the proposed regulation, and by way of background, governments have really left this area of restraints and confidentiality largely to the parties to an employment contract to regulate themselves. So this is really the first big move into the area of regulation in relation to the issue of restraints. The plan is to ban non-compete clauses for around 3 million workers who earn less than the high income threshold prescribed under the Fair Work Act, which is currently $175,000. What that really is flagging, if you earn more then it's open for parties, it's open for your employer to impose a restraint upon you under the contract. Secondly, Labor's reforms seem to be limited to a prohibition on non-complete clauses that place restrictions on a worker from leaving the employer to work for a competitor in the same industry. Courts have, as we've discussed today, become increasingly reluctant to enforce this type of restraint in any event, which is viewed at the extreme end. Labor's proposed prohibition does not therefore appear to affect other common types of restraints that prevent a former worker from the following activities, the non-solicitation type activities that we've discussed today, that is related to solicitation of former clients, or the non-recruitment restraint, that is the restraint against encouraging their work colleagues to leave their old employer. The Treasurer did indicate, though, this issue of restraints was to be the subject of further consultation, so these areas could come into becoming a target for the government in the future. In terms of the timing of this particular regulation, despite the apparent benefits that have been described, there doesn't seem to be a mad rush to implement these reforms. So the timeframe seems to be sometime next year or even 2027. Further, and importantly for employers, Labor is committed that this IR platform, through these reforms, will not be retrospective, which is the same approach that it's taken in relation to the regulation of fixed-term contracts that it's done in its last term. So in terms of finishing off in terms of the future options available to employers, firstly, business does have a window in the next year or so to put in place restraint of trade clauses with its senior and key staff where they are earning less than the high income threshold that will not be impacted by reforms. Secondly, business still appears to be able to continue to use common form of restraints, such as those that prohibit solicitation of clients despite these reforms. Thirdly, as Joe and Helene discussed today, there are some other options that are available, including the use of tight confidentiality clauses and indemnity and liquidated damages clauses. Fourthly, the other option for business is to review the length of termination periods for their senior and key staff. Business has already sought to use this option in response to the ongoing skills shortage, and it's certainly common for our team to be engaged by businesses who are looking at the length of the notice period, and many are looking at 2 to 3 months or even up to 6 months as a notice period for their senior and key employees to lock them in and ensure that they can't leave quickly if they decide to go to your competitors. So that's what I was going to say in relation to Labor's proposed reforms.
Can I just add one thing? There was a question over there. I think it might have been you earlier about you did all the right things and they told you to bugger off.
Mm-hmm.
Quite often what happens, the first step is the injunction, interim injunction. Quite often once you've done that, that will bring the parties to a resolution. Because if you're able to get an injunction to stop someone communicating with all the clients, that's pretty much the end of the ball game. And they'll, you then have negotiations where you bring the whole thing to an end. It's not often that it goes all the way through, that you have to issue a statement of claim, then you have to file. Sorry?
I had no proof of that she was working in the same field, just that her ABN had got reactivated 5 days after she left.
Yeah.
She's
Didn't have any confidential information that she pinched or anything like that.
oh yeah.
You had all that.
I had all that.
Oh yeah, that's great.
But she just denied it and then said, I've taken my laptop to get it cleaned by an IT person, had her an IP number and everything from Microsoft Court reports.
But I mean, if you had made an application to the court for an interim injunction, you may have got it, and you probably would have got orders. Because at the time that we applied for an interim injunction, you also applied for her to deliver up her computer, her phone records, her phone, all that. She's got to deliver it up, whether she likes it or not. And I mean, people think that, they delete things in the delete folder, but it's gone. It's not. Still there.
I still haven't cancelled her email. So I've still got it.
Yeah.
Just waiting.
So, quick question for you, if I can. Back to the non-compete, non-solicitation, those things, particularly as incomplete. In the context of the sale of a business, where an incoming purchaser wants to make sure the outgoing vendor doesn't compete, and he's parting with real consideration for the business, is it easier then to enforce a non-compete?
I'd say the question whether it's easy or not. I mean, what you've got then is the consideration for it, which is a really important factor. So, well, I suppose from that point of view, yes, it is easier.
Technical.
Yeah.
So you just
Yeah, and that's the non-solicitation of those existing clients that you've acquired.
yeah,
Yeah.
exactly.
Just put that in through an agreement for an impending business.
Yeah, there you go. Yeah. Okay, so just quickly looking at the takeaways, we've got written agreements contain bespoke and measured restraints and confidentiality clauses. Remember, non-solicitation is broadly interpreted. The use of social media through LinkedIn and Facebook provide a springboard for solicitation. I think that can be underestimated, by the way. We'll see a lot in the legal industry through LinkedIn. And if you are concerned, be decisive in your actions and take proactive steps to collate evidence to assist in obtaining injunctive relief. So that is presentation today. Thank you very much for coming in. We appreciate your time. Please let us know if you have any questions.